Yeah, it's
All right.
Civil 37.
Sorry about that, Your Honor. McNulty just got discharged from hospital.
Oh, okay. Good to hear.
Yeah.
All right. Here for the legislative contest hearing for the SASM and DOC Authorization Act. There's a change that is roughly about being able to release investigative information to the public. Calpret here has contested. I'm here as a mediator. I'm not making any decisions. I'm here to just make sure things aren't getting stuck. So proud when you're ready with your opening.
Perfect. 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 All right. This is quite simple.
God, I hope there's a crash out.
I mean, the sitting justice said it himself. It's about releasing information to the public. Why does what's being added to the legislation encompass so much? There's a difference between sharing information with the public that they deserve to be privy to. That level of transparency is extended to all PD leaders and whatnot. People know the basic ways to do this shit. But essentially, I'll even read this to you, what I am contesting, because I believe the people do need to hear it. Even though they are few, every person here matters to me. The piece that is being added to this legislation is simple. The San Andreas State Marshals shall have the authority to determine whether investigative information in their custody may be released to the public and may, at their discretion, authorize the release of such information when they determine it serves the public interest and the principles of transparency. Take a look at that first sentence. They decide. There's no litmus for like what sets this precedence. They get to decide. What's in their custody? It's easier to name what isn't in their custody. All information's in their custody. They have access to everything. This whole thing could be simple. Just this one sentence alone could be, shrunken down to like just a few words. Everything should just be gone. Now, on to the next sentence. Investigative information includes, but is not limited to, any information gathered or created during an investigation. Whose investigation? Review. Whose review? Or oversight action. Whose oversight action? Including reports. Whose reports? Notes. Whose notes? Statements. Whose statements? Recordings? Whose recordings? Photos? Communication? And related materials? Whether the matter is ongoing or closed. That means they could paint a narrative about someone to the public with no way for them to defend themselves in order to fucking get to a goal. Very much like they did with my prosecution. The San Andreas State Marshals, hold on, I skipped a part. Information released at the San Andreas State Marshals' discretion in this manner is still exempt from FOIA, provided that the investigation is still pending, ongoing, as decided by the FOIA process. I added a word there by accident. Listen, people, this is dangerous. You don't need this. All right? There's a difference between saying so-and-so's got a warrant. All right? They're pending charges. All right? They're a current threat. All right? You got something on these motherfuckers. All right? The public should know. I mean, that's already public information. If you got a warrant, it's listed. Oh, except when you have a marshal warrant. That's not listed. I mean, they're already violating rights just by that one process alone. This entire thing is fucked. This entire paragraph that they're trying to get added, it isn't about sharing information with the public. It's about sharing information about whatever to whoever they want. They could take Tyler Peters' investigation, go share it immediately with whoever. Well, we deemed it necessary. And it doesn't say who can do this. It just says the San Andreas State Marshals. That includes all of them. That means you could have a martial rookie doing whatever he wants. I mean, if he believes it so, there you go. This is too vague. This is too much. This is too powerful. This entire paragraph needs a rewrite. I do agree that to a certain extent, all PD bodies should have something about doing, introducing information to the public. But we need to outline when something is information that should be listed with the public. There needs to be certain parameters hit. Suspicions, potential involvement, stuff like that. There's none of this here. This actually, I don't even understand how this is a thing, because this literally goes against, everybody's right to privacy. Everybody's right to process, to due process, fair trial. How fair is a trial and how fair is a due process if a policing agent's able to slander you and share only bits of information and then exclude you from it? I'm talking about the potentials here. The potential here is too damning to allow this to go through. We cannot allow this to happen. I demand that this be rewritten, some type of standard and stuff like that be, ironed out, something that doesn't violate people's rights, something that doesn't go above and beyond. This is an information power grab. This is the ability to share anything about anything and get away with it. It says nothing in here about news media. It says nothing in here. Making the public aware is vague. The public doesn't mean it's everybody in this room. One person could be the public that they're choosing to make aware. Things need to be more defined, because this is a dangerous, slippery slope. And I don't even understand how this could pass the constitutionality check, if I'm being honest. Because it violates at least 3 constitutional rights that are afforded everybody in Los Santos.
Okay, thank you, Ted. Director Knight, when you're ready.
Absolutely. Your Honor, ladies and gentlemen, about 4 months ago, the SASM approached Charles Danger and Mayor Dawn. The intention: the public needed to be aware of ongoing threats that the state faced, be it the faceless, be it the plague, be it the green gobbler. Most people's access to information today is primarily through the Chronicle, a institute that all law enforcement try to work with in order to ensure that the public is aware of the ongoings in the very home that they live. Many years ago, some of y'all may remember Sanguine. Some of you may have differing opinions on the matter, but I think we can all agree on one thing. Why did we go to war? Very few people even today know the why. At the time, the government refused to release any information to the public in advance of battleships taking to sea with members of law enforcement being placed in battle against an enemy that they themselves may have not understood what the war was about and what the fight was for. When those veterans made their way back after winning the war, there were still questions. Why did we go? What were the reasons? Where was the evidence? We cannot allow that to happen again. Many people in the public today ask the question, why do we even face the faceless? What's so bad about them? I've heard on the streets, people begin to wonder if the faceless are the good guys in all of this. But how can any rational human being make any determination unless they have the evidence that is locked behind lock and key in our MDTs, accessible only to those that have the proper authorizations? We proposed language on roughly 3 months ago updated language roughly 2 months ago, and with the assistance of the DOJ, presented a proposal that information that was locked behind the marshals could, in a legal fashion, be released to the public so that the public could themselves determine what was the truth. That is not my job. It's not the job of any institute to determine how you should feel about the matter. Some may agree, some may disagree. But unless they have that information, there is no room for decision making. Now, you heard today by Pred that this is, I don't know what arguments he's really making. I think the language is rather clear, and to be rather straightforward, it's not my language. It's not the DOJ's language. As I understand, this was cleaned up, and it's rather straightforward. If we have matters pertaining to public safety, it should be released. Files should be released. And if there is any concern of files being released that affect individuals, we already have processes in place. ACR us, impeach us, but don't allow information to be kept strictly to the government due to unreasonable fear-mongering. Thank you.
All right, thank
Do I
you,
get-
Director.
Do I
now
go
you,
again?
now you two have a conversation.
All right.
All right. I mean,
Uh,
I feel like it's simple. Why have such a big scope if it's just about martial investigations into the faceless? Why not just share that information anyway? I mean, you don't even share that information with the police departments. Now you're in here saying you want to share it with the public?
Well, that's not true, first and foremost.
Pretty true. I was chief.
Okay.
I know
As of,
firsthand.
so I'll make this, is this on oath? Well, let's
You
pretend
are
it is.
spot on, but
Okay,
it's
easy
up to
enough.
you.
The vast majority of investigative files pertaining to the faceless, along with other state matters, are available to all three police departments. That does require reading and looking at the MDT in order to make those assertions. So that
I get
statement
that.
is categorically false. But
think so.
secondly, this is not about just the faceless. It includes matters of the Green Gobbler. It includes matters surrounding the archivist, which some in the audience are probably aware of. It is not strictly about one particular investigation, but matters of health and public safety. And
All right, then
I
why
think
don't you
your
just
question,
make that the scope?
if I could, please. If the concern here is why is it being written into law, is because even tomorrow I may not be the director, and clarity in legislation is important so that if a law enforcement agency such as the SASM releases something, it's under clear gated there's a clear gated process, which is exactly what this is.
Why the vagueness? Why not just say, hey, we wish to share information with the public about statewide threats? Why not just make the scope a statewide threat, something that is very much your outlined oversight and jurisdiction? And instead, what you choose to do is you make it any and all reports in your custody. That is not defined. Everything's in your custody. Medical reports.
That is not
police
accurate.
Investigations. I have
Access
confirmation saying that you have view of those reports.
Okay. I think there is. I think I see where the concern is, and I think it's more of an educational one. Custody means ownership. So custody means if it were a state marshal report, that means it is in our custody.
What stops you from taking information from other reports and putting it into a state marshal
If I could,
report?
please.
Okay. Let's not talk over each other. We'll just, if I need to, I'll start
Yeah.
timing each other on each side. But
Absolutely. If
keep
it is a
normal.
medical report, that is under the purview of SAMA. If it is a report that consists of 2 departments, 3 departments, that would be custody of all 3, right? So to be able to access information does not infer custody, right? Custody means ownership. So I'll give you a working example, right? If I own a pit bull and I have purchased it, I am the legal owner of that pit bull. It is in my custody. However, if you come to my house and you play with my dog, that is not in your custody. You're just playing with the dog. You have access to the dog, right? But if the concern is one of, if this is a hooked on phonics conversation, Your Honor, we are very open to having the writers of this, whoever they may be, simplify some of the wording.
Why not just make the scope what it is you want to be? I get it. You want to take time to try and insult me, but I mean, why not just make the scope then what it is? Statewide threats. Why make it so big? Why not just say, hey, we wish to share information about statewide threats, proven statewide threats with the peoples of Los Santos? What does that have? Why isn't that just the appropriate way to go about it then? Why reach for so much? And just so you know, custody has several definitions. All right, the definition that you use, I mean, quite frankly, anything's technically in your custody in an information format. I mean, so you can insult me all you want by trying to gaslight everybody here and sidestep what the issue is. Why not just say, hey, honestly, we'll change the legislation that we're proposing to just have complete to switch it over to the scope of just statewide threats and information shared with the public. Why fight this then? If that's what you already want to do, perfect. Why not just why contest at this point? Why go against it? Why not just say you want to amend it to that?
But did we not just agree to? Isn't that what we just said? If the language needs to be simplified, we have no problem with that.
That's not simplified. I mean, why don't you just say it outright that you just wanted to include statewide threats? What's simplification going to solve? I'm not asking for simplification. I'm asking to know exactly what it is, what the scope is of it. Mm-hmm. There's no simplification here.
Yeah. So, like I said at the introduction, the original language was very different. I'm actually unsure who the writers of the updated version was, but I think both.
It was me.
Oh, is you? Oh, hell yeah! I thought this was really well written there, Your Honor.
Well, Blunt wrote the most of it. I just changed a couple words here and there.
Yeah. So,
I didn't write it.
I said Blunt.
So,
Angel probably has the answer for that one.
If you wish, yeah, if you wish, I can read you the original language, and then you've seen the updated language.
I'm not interested in that.
But if I may, I think your concern is you want it limited to just statewide threats. Could you point out in this paragraph here what section specifically infers something otherwise?
What do you mean? What section specifically points that out otherwise?
So there's green text on the City Hall forum.
I'm aware. I read the whole thing to the courtroom.
Which sentence?
I pointed it out while I read it.
Or part of the sentence?
I already did that.
Okay. Well, I may have missed it. So
I know you were too busy on your phone the whole time while I was talking. Very disrespectful.
Okay.
Okay. Let's.
If you could point. Go ahead.
From what I understand, Fred's point is that the reports in SASM custody, his interpretation is that it is too broad. Brian is saying that Brian is then asking, is that the part that you're pointing out, Fred, or is it a different part?
Mm.
I mean, it's quite a few, but that's pretty much the gist of it is that in their custody is a very wide scope. They can they have access to all the files. They can take anything and transition it to their custody. I did it when I was a marshal, when I was working investigations. All right, I would work my own shit and I would pick from their stuff, move it on over to mine while I would give them oversight. All right, is that if they were to do that with LSPD information, now is it technically in their custody? Did they skirt the system? Right. The issue is the vagueness of all this. The simple thing here is Brian Knight's made it clear that it's just about statewide threats. Why not just not make it information about statewide threats like he put forward? The archivist, the faceless, whatever other bullshit's going on, I don't give a fuck about. All right, make that the scope of this thing, sharing information of statewide threats. Leave the rest of it alone, because then we're just opening up the door to all types of fuckery that could take place, because it's impossible to define their custody because they have access to all reports.
Okay.
Could I respond to this? As a point of clarity, what category outside of statewide threats do you believe the public should not have the legal right to be aware of? In the guise of transparency.
What does that have to do with this? What does that have to do with this? Brian, listen. The bullshit that you try and pull on people don't work on me. We're not here talking about
a clarifying question.
It's not a clarifying question. We're here talking about one fucking paragraph in proposed legislation. I don't want to talk about anything else. All right, I'm not going to be fucking looped around all goddamn day. I've made it very clear to the court. I've made it very clear to the people here. All right, I don't want to get into some dumb fuckery talk. I want to talk very clear and concise about the one thing that we're here about, and that's it.
Okay. My response to this is going to be rather simple. Go ahead, Your Honor.
Brian has seemed amenable to some modification of the language. Right, you as the person bringing this contest forward, do you have a proposed version of the language you would like to see? I understand the intent of your points. Do you have a specific wording that would satisfy your
there is no point here.
Instead of it talking about, just information in their custody, I kind of think it would be better to take that part out and reword it to that the people, the San Andreas State Marshals will shall have the authority to share information of statewide threats. And then that kind of trickles into the stuff where they're talking about their evidence and the reports and stuff, because then the scope is just narrowed down. It's a statewide. If that's what it's about, is statewide threats, let it be about statewide threats, talking to the people about what's going on with the faceless, talking to people what's going on with the green gobbler and other shit. Let's just keep the scope at that, so we don't have to worry about any other type of information leak. That's the gist of it. I didn't write anything up. I didn't think it's my job to write it up. It's on them.
Wait, huh?
Director, do you have a response?
Yeah, no, absolutely. Okay. I think it is important to kind of, in writing, kind of provide a alternative. I think it simplifies things. But on the my concern generally with the wording of the contester here is statewide threats does not necessitate equaling the faceless and the green gobbler. As noted in my opening, statewide threats
they were just examples,
if I may include things like the plague, right? Other ongoing things. Now, those other ongoing things may require joint cooperation. So if, for example, let's use the plague as an example, right? That would require cooperation with the custodians of the medical information, which would be SAMA. However, my concern with the wording of the auditor here is hearing just statewide threats actually, if anything, makes me very much disagree. What are we trying to then suppress? We stand firm that if I'm going to propose a alternative to this alternative, that if these categoried reports are owned by SASM, and if custody is a confusing word, I'm open for it being expanded on to define exactly what custody means. so there is no confusion, is that I believe the public should know about everything, right? If I, the director, Brian Knight, kicked a cat 6 months ago, and a future director wishes to release that, that sucks for me, but the public should know, right? And it kind of sounds like what I'm hearing is that information should be suppressed by the public. And I have to say why, right? How does the public know what exists without first knowing what's behind the veil? It's a very dangerous road.
That's spoken from the guy who keeps all his reports under tabs, locks, and keys, Brian. What a bunch of fucking fluff that was.
And that
brother.
is what this is, right? The access to information that the government has should be released. Things should be kept in lock and key up to a certain time for active investigations. But beyond that, I'm a strong believer that the public should have access to it.
But what about your fellow police departments? Why not share information with them? You keep all your reports under lock and key from them, and now you say, hey, information, let's talk about defining custody if that condescending bullshit. All right. I mean, what are you talking about here anymore? I mean, it's not about statewide threats now. Before you said it's about making the public known as statewide threats, and now it's just like, well, what if we want to make them known about the plague? What if we want to make them known about this? Hey, how about we just define it whatever's in a Marshall report? All right, you're kind of like, now you went from before being agreeable, us talking about the same thing, to trying to widen the scope for what it is that you deem necessary that the public see.
I'll keep it short. All of this was stated in the introduction, and then you scoped it smaller and then started to argue that point, which was a straw man. And as a consequence of the limiting of the scope to faceless is where this concern came from, right?
It's not limiting the scope, it's to statewide threats.
Okay. I think as long as those things are rather defined, so that there is no limiting of scope to prevent the public from being made aware of things that we believe they should be made aware of, we have no problem with that.
It's not about statewide threats. It's just about what you deem necessary for the public to know.
Well, so I'll explain, right? Statewide threat is subjective, right? I'm going to have a perception of what that means. You're going to have a perception of what that means. However, in this back and forth that we're having, if we are limiting statewide threats to only have meaning to the faceless and the green gobbler, but refuse to acknowledge something like like a plague, which affects every member of the citizenry, there becomes a concern, right? So what I'm trying to point out here is, while I'm opening to having that clarity in this verbiage, it should be done in a fashion where it does not get inferred to limit just acts of violence, right? I would like to finally point out that some of the concerns that were raised, the what ifs, have a counter to it: ACRs and impeachments. Now I know there's a lot of allegations thrown around, unsubstantiated. But once again, if those allegations are true, there are mechanics that we have in due process through the ACR and impeachment process that can resolve those things. So
ain't nobody want to do that shit, dog.
Yeah.
Okay. So the way this ends is one of two ways. Either both sides agree to an amendment, a rewording that gets proposed, and we go forward from there.
Yeah, absolutely.
Both sides agree we'll not come into an agreement, it goes to a public vote. Now, I have put the wording in question on the board. Brett, as the person bringing the contest, can you point to where you would like changes made? And what the changes would be to Director Knight, to see if we can come to this agreement, or if it's
beautiful.
To a vote.
Yeah, the scope. Do you want me to answer now, Your Honor?
Yes, please.
I do know that there are people in the crowd that want to share their opinion on this as well. Is there going to be a time for that before I start pointing this stuff out, or time after? I mean, how do you want to do these things there, Justice Falconer?
Let's have you point out.
Right now,
what
Biden
you
giving
would like
soft jabs.
changed
I mean, it's true.
specifically
This
first, and
isn't.
we'll see how it goes from there.
This is like an
I got
hooked
you.
on
So, I mean,
phonics
the
argument.
clear scope
In
is
Brian's
the San Andreas
eyes,
State
it's so.
Marshals shall have the authority to determine whether investigative information in their custody may be released to the public. All right, I think it's real simple. You know, we have to find a way to narrow the scope down. All right, because investigative information is it's a wide array of what it could be. Let's just make it be we have the ability to share information about statewide threats. You know, I mean, it's that simple. I mean, I know Brian pointed out earlier, Your Honor, that he said something about the faceless, and then he said, well, the plague. I mean, I would argue that any type of disease coming to our island would be a statewide emergency, a statewide threat. I feel like defining something that's a statewide threat is real simple. A fighter jet flying over the island, armed with missiles. That's obviously a fucking statewide threat. No one's going to contest that. All right. But is Valdo rolling around in his wheelchair at the senior buns with the hammer in hand? I think we would all say that's not a statewide threat, and that's very much a controlled threat at the senior buns at the time. I mean, I don't understand why this is. I feel like this is something simple because people, Your Honor, Brian came in here and said strictly what this was about, sharing the information to statewide threats. I asked him to narrow the scope down to say, hey, just share information about statewide threats then. That's fine. And then it turned into, well, I want to do more than that. It comes down to what I deem necessary. You know, so you've seen it in real time what this is. This is like an information power grab in a vacuum. There's no straw man argument here. It's just an argument. It's that simple. You can't allow our information, yes, our information, to be utilized against us in some type of potential narrative and criminal capacity. We are innocent until proven guilty. We are not guilty until proven innocent. And this could potentially open the door that jeopardizes the painting of narratives, and people will not be able to argue against it. Keep it to statewide threats. Keep it to persons that are statewide threats. But do not broaden the scope and make it so it can be whatever you determine the public may know. Because what we all know will happen is, what exactly do you think? What information isn't up for grabs? How is this right? How is this even constitutional? Guilty until proven innocent really seems to be a pattern of the San Andreas State Marshals.
Yeah, we're getting a bit
And if
off
we
topic
allow,
there, Brad.
it has a lot to do with where I'm going, because essentially being able to share any information, you can paint whatever narrative you want and then hide it behind the FOIA process. I know that there are a lot of peoples here today, quite a few, that actually want to share their opinion on this as well.
Okay. Before we get to that, so from what I took from what Pred said there, the change that would satisfy you, Pred, is if after the bit that said, this would be the new wording, right? The San Andreas State Marshals have the authority to determine whether investigative information pertaining to statewide threats in their custody may be released, and then everything else would be the same. Would that satisfy you?
I'd really have to sit down and think about how they could fuck us all over, but I wouldn't mind kind of going over.
From what I just said, the only words added are pertaining to statewide threats. Every other word would be the same. So,
Hey, yo, that's crazy.
I'd really have to think of a way that they could try and fuck us all over with that. So I might have to like hit the drawing board.
Unfortunately, you know, we're here for this to see if it goes to a vote or if it gets an amended wording. So we don't really have that time.
So if it goes to so the process is, if we can't come to a decision here and amend the wording, I'll be honest. I'll be honest. I think it should go to a public vote.
Oh, easy.
Okay.
I think the whole thing is too dangerous. I think the whole thing is just, it's a dangerous stepping stone. We're just traveling more and more towards some type of authoritative policing body that can just dictate everything to everybody.
Okay, so am I correct in understanding that based on this hearing, you don't think there is a resolution that you can find here?
I tried finding a resolution with Mr. Knight. He made it clear that he didn't want to agree with my amended resolution, so fuck it, get the whole thing gone.
If I could respond to that, I'm still kind of awaiting a proposed alteration to this. In fact, the one that you just provided there, Faulkner, and the means that you did, I think is very amicable, or amenable. I think we should be following the process that has been defined. So to me, this sort of comes across as, I'm scared of words, let's go to vote, so I could fearmonger away transparency of the government, right?
I don't know why you're saying what you're doing is what I'm doing.
Yeah,
That's crazy.
I would love to hear a proposed alternative, to be honest. And
I offered you that.
The one that Faulkner just noted?
Yeah. I offered you.
No, the one that
beforehand.
Faulkner just noted is very that's perfectly fine.
What I said the
Faulkner.
whole time that you told me no on. What I said the whole time that you fought me on. Yeah, fuck them. Let it go to vote.
Okay.
Hey, give me one moment.
What is this? Is this like an appeal?
Pretty sure, yeah.
Oh, yeah.
Yeah. I am so confused. So
That's fair.
So, Fred, that is the wording that Brian just agreed to. Do you
Let
agree
me
to
see.
that wording?
San Andreas State Marshal shall have the authority to determine whether investigative information pertaining to statewide threats in their custody may be released. Can we potentially try defining what a statewide threat is real quick?
that
See if we
is
can set-
exactly my point earlier.
What do you
These
mean?
are subjective words. No matter which words you put in there, they are subjective. And as is many
Only
words in
subjective to
legislation.
someone who's trying to manipulate everybody.
No,
Pretty clear what a statewide threat is.
And as a well, you're asking for a definition. We're actually both agreeing right now. And the mechanism by which, if someone reads something in bad faith and does something that is unconstitutional or gross negligence, that's when you ACR and impeach them, right? I agree with you. Statewide threats, by adding that, you actually create more vagueness, right? Even though that is inherent in the words that were already present. Now, if the fear is,
how is going from saying information in our custody to statewide threats more vague? It doesn't even make sense, Brian. Wake the fuck up, man.
Because you just got done saying statewide threats needs to be defined, right? You sort of conceded the point.
That's not conceding the point. You said all information in your custody in the original.
It's fine.
And then you say statewide threats is more vague.
It's fine. I'm okay to hear how you want to alter this.
Okay, so we've taken a step.
Fuck them. I want the whole thing gone.
Okay.
Fred, I am officially asking you, are you saying that you can find no resolution based on this hearing?
Yeah, maybe we should hear some peoples from the crowds and see what they got to say about this.
Oh, okay.
I think,
Your Honor, I am very
speak.
open to individuals from the crowd who may have a better way of explaining the concerns or alternatives to the wording. Come forward. At the end of the day, our only interest is being transparent to the citizenry over statewide threats. And if we can come to a resolution, I am all for that, as is my department.
Okay.
Yep.
If a member of the public here wishes to make their voice heard, please state your name, which side you are, if you are for or against
Right,
the changes
neither
being
of
proposed.
Those two are going to propose any
And
changes. They're just
then
going to
speak
rail
your
on the
mind.
current one.
My name is Carmine Costello, wrongfully prosecuted, demonized by the marshals. I have something I'd like to say that I think could fix this disagreement here.
Okay, what
If
side are you
we-
on, Carmine?
I am against this amendment going through, as it stands.
Hey, you already know what side he's on.
I'm a home team. So why don't we determine like the onus of discretion rather than putting it on the marshals, who, for my own personal reasons, think may have ulterior motives and act in manners that are, in
what's
my
the
opinion, uncouth?
legislation?
Why don't we let
for how
discretion
this
fall
works?
on and the interpretation of a
Trying
statewide
to
press fall on
find
the
it.
judiciary? Have a process like how we do search warrants or whatever, but for the information they plan on releasing, let the judges decide, or the other agencies that are involved in whatever information it is they plan on stealing and taking into their custody and then releasing unilaterally.
Let's not use charged language like stealing.
My apologies. Taking into their custody unilaterally.
That's a great idea.
Does either side have a response to what Mr. Costello put forward?
Is
I
the
think it's
recommendation that there would be, we're talking about the language edit, or that there would be a DOJ sign off for any releases of documentation?
Doesn't just have to be DOJ, it can be the agencies involved. So they can make a unilateral decision on what information gets out there. You never know. Who knows? Maybe they release something that slanders a good man's name in an attempt to run a propaganda campaign against them to ruin their reputation. You never know with these marshals. You never know.
Well, I'm going to kind of not address the latter point, given that ACRs and impeachments already exist, as has kind of been noted. Those are already covered by gross negligence, etc. However, that is unreasonable. I think getting DOJ involved with the release of documents for statewide matters inherently creates a confliction point where if something were, say, let's use an example, right? Including the working example that Carmine just kind of noted here. Let's say we were to get drunk with power and say, you know what, we're going to release every damn report involving Carmine Costello to the public, despite it being available to the public today via FOIA. And we did so in a manner that could be articulated to be gross negligence. Well, at that point in time, Carmine can go in ACR and impeach. Now, if we were to equally, under this suggestion, go to the DOJ and say, hey guys, DOJ, we want to go release these things, we're now conflicting y'all from being able to oversee the ACR and in the impeachment or any civil actions that may come out of it, et cetera, et cetera.
Public information isn't conflictory. Yeah. Once it hits public status or like the public forefront, it's not conflictory anymore because it's information anyone can have access to, Brian.
Yes, you're right.
Which is why they wouldn't need
which is why they wouldn't need to do the sign off. But by them authorizing it, they then become, if the DOJ is signing off on it, they would be also the party that would be conflicted for overseeing their own case.
Why would they be conflicted for signing information into public space? They would be conflicted for not signing over information and being aware of it into the public space. You got it backwards. And there's enough seating judges that, you literally got the whole thing backwards. You're saying that they'd be conflicted for signing information that's going to be entering the public space. What would conflict them is reading information that you wish to make present to the public space and then telling you, no, you can't make that present to the public. That would be conflictory. That would be different because once it hits the public space, it's knowledge that anyone can have access to. It's not conflictory.
Carmine, am I correct in saying that you believe that the DOJ should sign off on any releases?
No, you're wrong. I didn't say that. I said the DOJ could be a party. You can also have the mayors or members of policing, like the chief or the sheriff, other agencies that may not have the same confirmation bias as the marshals do.
So
Well
is
said.
it accurate in saying that there should be more government red tape from releasing government documents? Damn,
On the marshals,
that's crazy.
yes. Yes, on the marshals, yes.
Okay.
Yeah.
Appreciate your input, Carmine. There's a line behind you, so
Hey,
Chris.
smoked emoji. Dap me up.
Hello, Nathaniel Grayson. I have issues with this legislation as one of the signatories on the pred.
Phyllis here.
I don't know.
Okay,
You didn't even
so-
write this. I wrote it.
Initially, I think the big conversation that's going on about
Oh, dude, I love this so much. I
statewide
love this
threats
so
could be resolved very easily, and you could also already get DOJ involvement in it by changing that to enemies of the state. We already have legislation that outlines what an enemy of the state is, how something is designated an enemy of the state. I think statewide threat skirts that just because it's different terminology. You go to enemies of the state. Yes, it limits the scope more for things like natural disasters or plagues. I think you could provide different articulation for that outside of criminality. My biggest issue with this, and the reason that I signed the petition, is the part where it says whether the matter is ongoing or closed. I believe that, when you're discussing an ongoing matter, something within statute limitations that could go to court, any release of public information about an ongoing investigation inherently poisons the trial of the individuals involved, whether they be a statewide threat or not. If that information is released to the public, if active investigation information is
Only if
released
we
to the
had jury
public,
trials, which
then
we
it
don't
is
have.
released to the judiciary. We may not have jurors, but we have a judiciary who will be then open to seeing that information and potentially poisoned before a trial occurred. No information should be made public about an ongoing investigation that has not yet gone to trial or is within the statute of limitations. That is a problem, and it can be avoided right now by removing that wording. So those are my problems with it. That's why I signed.
Very valid.
Are you asking it to be limited to the scope of enemy of the state or removing some wording? And if wording, which wording in particular?
Okay, so Ryan, what I'm saying is, I think if you're willing to go to statewide threat, you should go to enemy of the state, because enemy of the state directly is already legislated and has a procedure
Okay.
of how something is designated an enemy of the state, right? It already means something in San Andreas. That's new terminology that doesn't have a definition, so it still falls into the problem that we had before, right? It's too vague. I think if you go to enemy of the state, it's defined. My specific issue, if you go near the bottom and it says whether the matter is ongoing or closed, I think it shouldn't involve ongoing matters whatsoever. I think you can poison trials and deny people due process. So I would remove ongoing. I think it should only be things that are outside of statute limitations.
Okay, so you're foregoing the enemy of the state thing because that is way too close of a scope, which was the initial point made during the back and forth myself and Pred had, right? Natural disasters, diseases, etc.
I think
Right.
you can find another line,
Okay.
You can put something specifically in to cover those instances, because I don't think they have the same issues with, denying individuals their rights to a fair trial, right? Like if there's a plague going on, it's a totally different matter than if
Okay.
there's a criminal investigation occurring.
So sort of 2 points here, right? One is of some of these concerns you brought up, right? Involving people's rights and this and that. Are those not resolvable through a ACR and impeachment?
I think if you can fix them before they happen, I think specifically with people's right to a due process. But if this
But
goes
they
wrong,
can,
Ryan,
right?
if you can ACR after the fact or impeach somebody after the fact, somebody's just had their rights violated, and you can fix it by fixing this legislation before it goes in.
But it can be resolved with the ACR and impeachment, right?
You can attempt to make it right. If somebody goes to jail and they never should
Okay.
have, I don't think
Yeah.
you can fix it by firing
yes.
somebody after the fact. No.
Okay. Is it accurate to say that you are pointing out that files can be released that may involve parties that may not yet have seen the light of day of court, and therefore it may paint a narrative of criminality before they have seen the light of court? Is that accurate?
Yes, specifically that criminality could be painted to a member of the judiciary who reads it.
Okay. So that is something that we have considered. The reason why it's not in this language is because we believe it to be inherent in existing legislation. So, for example, and we're going to use a hypothetical that has no actual merit. Let's say there was an organization called the Dumb Fucks, right? And the Dumb Fucks had, Chris Michaels in it as an actor. Chris Michaels would need to be redacted prior to the release of the documentation for that exact thing that you just brought up. So now, if we were to release that without his redaction, that would open us up for the ACR and the impeachment, right? So my point there is that this change does not remove all the other legislation. This paragraph is still within the scope of the Constitution and all the other legislation that exists. So I think that's already kind of self-resolving. The second point that I want to make here is to say that it should not pertain to ongoing matters is in and of itself concerning. The faceless is ongoing. The diseases can be ongoing. And I would actually like to point this out, and I hope you don't take this the wrong way, is back during Sanguine, you were one of the ones on recording who stated that you weren't sure why we were going to war, right? And I am saying you were right back then. And you should know why, what the lead up was, why the decisions were made before we went to war. And the same can be applied with any other major thing that law enforcement does, right? People shouldn't first learn of the plague after the person behind the plague is caught. They must learn it in advance.
Weren't you a big part of the movement against the Sanguine to violate their rights, remove their due process, and just fucking charge them criminally without taking them to court?
No. That was a
Didn't
state
you
decision.
work alongside in corresponding? That's wild.
Your Honor, regardless,
Brother, you're the problem.
I still maintain I still maintain my objections to this. I think there are problems that can be fixed with wording changes. I think 90% of this could be okay. I think it's
dude. I feel really good. I'm a damn warrior right now.
Involve individuals who could have their rights forfeited, their rights to a fair trial, because information is provided and available to people who will then have to make decisions on criminal culpability. I think that's a problem. I think you need to draw attention to it. You know, I think you need to look at it.
I would be, if I could there, Grayson, you didn't really answer my question. And the reason I brought that up is, has your mind changed over the last 3 years? And how would you allow the public with this wording to know about these things in advance of them taking place? And if you concede the fact that that particular names would be redacted, and if we do not redact them, we are open to existing legislation which allows for ACRs and impeachments, what is the concern, right?
Okay, absolutely, right? So, redactions. Yes, okay, let's add some lines about redactions for ongoing individuals so people aren't named publicly. Let's not just leave it vague, right? Add that. Add something.
Okay.
That's not there. Those protections are not legislated right now, Brian.
I disagree, but that's okay. I think there are functions that exist to counter that. If I released a report that said, Michael Johansson, right, runs around with his, donger out, 15 days after writing the report, he can ACR me, he can file a civil lawsuit, et cetera, right? So those things are legislated. However, I agree that if we need to write the obvious into here and expand this and say sensitive matters and individuals should be redacted, I'm okay with that. We're going to do it anyways. Like, we need to protect, we need to, you know, hide people's names from potential wrongdoing. We can redact it if that's what you're proposing.
And as far as Sanguine goes and the information going on, as I said, I think that
Unless,
if you change statewide threats to
sorry.
enemies of the state, there's a process there where if that enemies of the state process was in place back when I was a judge justice when Sanguine was going on, right? I think that information at a hearing to designate Sanguine as an enemy of the state would have been provided to the judiciary, right? I think we've already fixed that, Brian, hopefully those situations never occur again because other parts of the legislation are in place.
Be a
But I think
damn
tying
shame if
this
that happened again.
together with this legislation would only, you know, further empower it.
At what
All
point
right.
does this just feel nitpicky?
Thank you, Grayson.
Thank you, Your Honor.
Hey, my dog.
Hello, Your Honor. Name's Christopher Watt. I'm a simple officer with the LSPD, badge number 206. The part of this paragraph that I think should be changed is how statewide threats are determined. I do not believe that a statewide threat can be determined unilaterally by one single department. I did hear some
Go outside with me real fast.
examples here about plagues and things like that. I do believe that we should leave the medical part in the hands of professionals that know what they're doing. I do believe that
That's a self-defeating
there's
argument.
a totally different department that should handle this. I think the policing and investigations regarding policing should stay in the hands of the LEOs. And I do believe that a statewide threat should be defined clearly here. I don't think that it necessarily needs to be a DOJ thing, but we do have capable people that are appointed as, you know, chief of police, sheriff, director of the marshals. They can sit together. They can look at what is going on. They can read the documents, and that they can clearly determine what a statewide threat is. We entrust these people with
Pause for a sec. Some guy just shot on the floor.
Oh my
That
god!
guy did just shit on the floor. Damn, that's a big one. Watch out!
Don't stand in that, Angel. Don't
No,
step
you
in that.
stepped in
She
the
stepped in
shit.
it. She
Oh
stepped
my
in it.
god, you stepped in the shit.
No, I walked around it. No, I walked around it.
God.
No, I walked around it. You guys
Oh yeah,
have
she
bad
simply dodged it.
I simply dodged the shit.
I feel like that was like a political.
I'm a dangerous
statement
guy
right
to go against, chat, when it comes to this.
20 grand to clean up.
I'm way too autistic.
I need the money.
You know,
Yeah, both on camera. Sorry, what? Please continue.
We have these three people leading all three law enforcement departments. I believe we entrust the safety of the public within their hands. We entrust them to be responsible for our safety and protection. I do believe that they are the most competent people to determine what a statewide threat is. I don't think that it needs to be a unilateral decision. That is my objection to this thing. Obviously, when it comes to releasing of information, I'd rather it be more on the situation ongoing and not the people related to it, because that could infringe on their rights. That is true, what Grayson said earlier. But I'm more focused on what a statewide threat is and how that is defined.
Okay, thank you. Does either side have anything to say to that?
Given that we are not the ones that it was, you know, the contester that asked for the phraseology of pertaining to statewide threats be added, I'm not sure which side he's sort of arguing. That I think if there are, this all kind of goes back to, if this legislation is used in bad faith to do these scary hypotheticals, then there is already a resolution to that that currently exists. Separate from that, I do believe that the first half of his argument was pretty self-defeating, as he did note that things should be left to the experts, like in the case of Sama, for things like the plague. I don't necessarily disagree, but we agree to that in the sense that Sama and the state marshals, if there is a health hazard with criminal hazard intermixed, it would require both parties to communicate.
Why would it require both?
I can answer that question in a moment. But it is inherently self-defeating because when we talk about experts, the expertise is defined in legislation today. It's a statewide matter, right? That's what we are, the experts, right? And if we unexpertly release something, well, then you ACR and impeach. So to answer your question, Brett, what was the question yet?
Why would Sama have to cooperate with you in regards to information about viruses and stuff?
They don't.
What service do they have to do with you?
They don't necessarily. So as has been done in the past with the Black Plague, etc., the Sama director can release, hey, there's a plague happening, here's some medical related stuff. However, if there is cross expertise needed, so for example, if someone were producing some kind of, I don't know, like a pathogen, right, or like a virus, they would be handling the release of medical related things, whereas there would need to potentially be a release of information around the criminality surrounding it. Right? Think of a biological weapon, for example, right?
Why do you keep bringing up so many fucking hypotheticals, man?
It's
not. If there's something criminal going on, you should be involved. One second.
It's not a
hypothetical. If there's some criminal involved, if there's some criminal happen, then guess what? There should be an agency working alongside SAMA. But we're talking about what you said, generalization of bringing forth information about a virus and stuff, and you implied that they would have to work with you. My thing is, why would they work with you? They don't need to work with you on making the public aware of that. That's their prerogative. That's their wheelhouse. Now, if there was something criminal going on, yeah, then any policing agent could work with them. Whoever they really go to. I mean, I don't understand your point. I expected better from you today, honestly. You're asleep at the fucking wheel for this.
Okay.
Okay, we don't. Okay.
I'm actually.
It's just disappointing, Your Honor.
Okay. Well, I mean, I'd rather not bark. I'm just kind of rather use logic and what's written down.
Okay.
For the
legislative process, we don't need to bullshit back and forth. Thank you, Walt, for your point.
Easy.
We'll move on to the next person.
Good one, man.
If I may, Your Honor, just for the sake of the public, that wasn't a hypothetical. That was a situation about a year ago.
I am aware of Isaac Smith and all that.
Release the information then. There ain't nothing out of statute.
We also did work heavily with them.
Yeah.
Just a heads up.
This whole thing could have been an email.
Next in line, please.
Well, mine could have been an email. This one's actually juicy.
I'd like to, if I may, ask questions largely
Chad,
to,
this is why I don't become the prosecutor.
To kind of illuminate a deeper understanding of specifically what the concern is, if I may. Your Honor.
Yeah, I mean, Grayson doesn't need to answer. Yeah, I mean, neither does Pred, but Pred is the one who contesting it. But Grayson is welcome to answer if he wishes.
So
I think Grayson should.
Name, please.
Yeah, it was to Marshall Vale. So it's.
Thank you.
I'm trying to gain a deeper understanding, so I can't really say if I'm standing here or there. That being that, is the primary underlying concern here that a marshal with some kind of vendetta or some such could theoretically use said wording to release information that would compromise a person's professional or social integrity?
Not from me, no. That's not my worry at all. My worry is that even if it was accidentally, right? Okay, so for example,
Hello.
The Green Gobbler, right? The Green Gobbler was mentioned multiple times. Now, that individual was involved in a scene that involved a person who has since been exonerated of the crimes, right? But a third-party individual. If those police reports were released as a part of information about the Green Gobbler,
Where's
that
your
then
hazard
undermined
pay?
that individual's right to a fair trial, that's my problem, right? It's
Right.
about the things. Like if like Brian said, things about redactions, removals of names, all those things that would protect people who have not been charged, who have not, had their day in court. I think all of that thing's important for me. It's just about rights to a fair trial.
got you,
That's
Cal.
where I'm at. But it's not about maliciousness. It's not about malicious prosecution. It's not about somebody engaging in bad faith. It's about, even just mistakes happening. I understand Brian's point about, ACRs after the fact. I'd rather be preventative and stop people's rights being abused.
So run with me on this hypothetical then, because this is kind of what I was trying to get the understanding of. So let's say there's a group called the Dog Kickers. I want to talk on complete hypotheticals, right? Let's say there's a group called the Dog Kickers, and they go around kicking dogs in the face and body, right? And it's very dangerous kicking, and dog kicking is very illegal.
Yeah.
Now, surely with the wording of the way that this is, and the nature of an ongoing investigation, the information release as it pertains to the safety of the civilians and so on in San Andreas and the state of San Andreas, surely the nature of the release and the extent of the information that is released would and should, from a law enforcement perspective, be limited to, hey, people, these people are going around fucking kicking dogs in the face and body.
Yes.
Not, hey, we have reasonable suspicion but not probable cause that Matt Damon is going around kicking dogs.
There's a very big difference there.
Yeah, exactly. But why? This is what I'm trying to get at, and why I asked whether it was like your fear is that a vindictive person would use it to compromise someone's integrity. Well, can I just finish what I'm saying? This is, okay. This is what I was trying to get at, and what I was struggling to understand is, if your concern is not that it would be used maliciously to, target somebody, or Grayson, as you said, rightly said, which I was also going to ask about, poisoning the well or sort of biasing consciously or subconsciously, judges, and in the situation that there was a jury or some kind of public reckoning, those people for or against someone. Why would that information be released if the only reason for it being released would be to hinder, inhibit, or reduce the ongoing investigation, right? Like, I'm struggling to see why you fear that this information being released for the benefit of the state, like the people of the state, would be a bad thing.
Yeah, I mean, you're arguing
as
against
it is
yourself
written
right now.
No, this is what I'm trying to ask. I'm trying to understand exactly where you're coming from. I'm not arguing one way or the other. I'm just trying to sort of delve deeper into what you're saying.
I mean, there's a difference between releasing information.
Wait, is this the guy that shit on the floor?
That is the guy that shit on the floor. He's still got shit on his suspenders. Yeah, I mean, there's a difference, though, between, like, releasing vague information, like there's an organization going around kicking dogs, right? And then saying Kyle Pred kicked this dog on January 17th.
But why would that be released? As a statewide threat, why would that be released? Because if it was released, whatever law enforcement agency, not even specifically the marshals, but if you were going to state that information as a fact and release it, on a statewide level, why would that information be released were it not for the fact that there was already enough to prosecute that person would already be being prosecuted? This is what I'm trying to get at, because I don't understand it.
Oh my God, that's nice.
I'm not trying to be rude, but I don't 100% even understand what you're asking, because you're asking about like some type of hypothetical group that's like endangering a town, right? And
which would be a statewide threat.
Why would that be a statewide threat?
Well, this is what I'm just created a hypothetical group that would satisfy being a statewide threat rather than calling into question like current
goings on.
Well,
now we don't have statewide threat defined, right? It's based on, I think actually it was brought up best by like Grayson, where it said enemy of the state.
But I think part of what maybe the disconnect here is because you didn't answer the first question about, is part of your concern the role of bad faith actors in this with a vendetta releasing information? Is
Can I
that
answer
part of
from
your
my point
concern?
of view before Pred
Yeah, I
gets
think
to
you
that? 'Cause
should.
right. So here's my take, right? And again, I'm not firing shots, but like Vale's question to me is, but like, if everybody's got some common sense, what's the problem? Your Honor, we live in San Andreas. Not everybody has common sense. Common sense, not so common.
Evident.
Going to mention himself again.
And like, if everybody's a good faith actor, that's okay, right? But sometimes even people acting in the best faith make mistakes. And it's not like I'm trying to
That's what the
legislate around
ace-
the edges and make sure that nothing bad can ever happen. But I think there are very obvious issues that could occur that can be fixed with like 2 or 3 words being changed.
What are those 2 or 3
That's my
words,
point.
please?
Okay, so again, I
Please.
think statewide threats to enemy of the state. I think a line in there about natural disasters and medical emergencies, and then I don't like ongoing. Those are my issues.
Right, but if we're investigating something and it's got to a point where we're like, hey, the dog kickers are coming to kick everyone's fucking dog, you would rather that not be released.
That's vague.
But that's what it says. A
Still
statewide
ongoing.
threat, they're going to come kick everyone's dog. You would rather that it just not be released.
I think if you've gone to the Department of Justice, you've articulated why they're an enemy of the state, they get designated an enemy of the state, I think that opens you to have a lot more discretion, right? Because I think that's tied into other legislation with other procedures. I think that if we add in the line we talked about with Brian about, the redactions taking place and nobody's personally named, I wouldn't have any objections at that point, right? So if it's just like the dog kickers and it's a vague grouping, then,
Bro,
whatever.
Okay, so counterpoint. You don't want any personal information. So,
brother,
let's say with it is as it is now. Baldy McBaldson walks in and shoots the justice, and then says, "I'm gonna shoot every shop owner and business owner in San Andreas," and then disappears. Then we are not allowed to say, hey, the state marshals are going to, well, not that this would be a state matter, but I'm trying to spool up a hypothetical because it's quite hard to understand specifically what your concern is, despite repeatedly asking for it.
Because this is nitpicky.
So Baldy McBaldson there's a statewide manhunt for Baldy McBaldson, but we then have to keep it under lock and key because it's an ongoing investigation.
Why would you keep something under...
Well, that's the question.
Why
you're
Yes.
arguing for
All right, so
something
one
to be
second,
kept under
'cause
lock and key.
No one's... Listen, once you have a fucking warrant for somebody, that's public information in itself right there. The people who choose not to release what the charges are that they're looking at are the policing bodies. All right, I mean,
you
the second
don't
you have a warrant
necessarily
posted for Baldy McBalderson for shooting the justice and shit, that information is fucking processed in here. Baldy McBalderson's got a fucking warrant. It's public information. Telling the public that a guy who has a fucking public warrant isn't sharing information that people aren't privy to. You're muddling the water between public facts, like public information, and private information. We're here talking about private information. We're not talking about public information. The second a warrant gets posted, they can do whatever the fuck they want with it.
Okay.
That's public domain at that point.
So if you wished to limit this or change the verbiage to enemies of the state, let's say you just changed the verbiage of this as it is written right now in front of us from statewide threats to enemies of the state, right?
Yeah.
One could argue, let's say
This isn't going to be enemy of the
marshal
state.
receives what is deemed by whatever standards you want to come across, that there is a credible threat of a nuke on Sunday at 4 p.m. landing somewhere in the state. We don't know where. If you wish this to be limited to the enemies of the state or some such, I could see a situation where it would be technically illegal.
Chad, this is too real.
There's already legislation
limited
covering this now.
information.
There's already legislation.
But
I'm
this
actually-
is what I'm struggling to understand and why I keep asking.
Because you
Yeah.
keep asking hypotheticals, like,
No,
you know,
Because you won't like give specifics of what you actually
did.
believe
Yeah.
the problem to be. No, I
but it-
listened and I still don't understand.
I told you public information, you know, once a warrant's posted, like there's a difference between public and private information. This doesn't outline that.
if I may, the confusion that I think you're failing to pick up on here, Pred, is that this scenario that is being referenced, there is no necessary probable cause for an individual. Rather, they are unknown actors who are engaging in something that is a
Enemy
state
of the state is
concern.
defined, Brian. Enemy of the state's defined
Enemy
at
of-
a lot of levels.
Enemy of the state is very specific to a specific type of criminal organization. It does not cover other matters. And what you are suggesting by limiting it to enemies of the state, that would prevent other state matters from being information pertaining to non-enemy of the state actors or scenarios from being released to the public. That's what the heart of it is coming to. And and I agree with Vale, is she's simply trying to determine where the actual root cause of the concern is. If the root cause of the concern is individuals having their information released, as was said about 20 minutes ago, they would be redacted, right?
Because to release that information would only compromise and poison that ongoing
Yes.
investigation, right?
If
And
you're releasing
open the
information, one
agencies
second, this is
for
important. This is
suits.
important. When you, all right, listen. There's nothing stopping any of you from releasing redacted information now. Releasing redacted information is completely legal because you're
We
not.
know.
You're, okay, so then why are you arguing that right now?
As you can see with the initial filing, this has been put out so that it is clearly legal, so we don't have dumb fucks dragging us into court being confused as shit as to what's happening.
What do you? All right, so this is the
Let me
dumbest.
just-
Now we're going to-
So, no, wait.
Yeah.
So currently there is legislation that allows for states of emergency to be put forward, in which the state marshals and other bodies are allowed to put out big state of emergencies to give people generalized information about bad shit going down, right? All of that's already there. This is so broad and so open that it allows such a deluge of information to be released that, as far as I'm concerned, and the argument I've made since I got up and spoke about it, is it can infringe on people's rights to due process and a fair trial, right? That's my issue. My issue is the broad, sweeping, open scope of this piece of writing.
Would
I
a
think it needs to-
resolution where it notes that there should be a good faith effort to redact any information pertaining to individuals, something along those lines being placed in here, resolve your issue there, Grayson? Because we're planning on doing it anyways. If you want it in writing, I mean, that's good too. Like, we
Yeah, I mean, I
redact
would
it
argue
because
that
we're
that
not
would be
going to do
sufficient.
something illegal that's going to, subjugate,
But you're already on recording doing illegal stuff.
So okay, pause.
Huh.
Because it's
Let-
my
let's-
it's my time on the
let's
floor,
not
so
here.
give me a moment. Proposal: add a sentence at the end that states the San Andreas State Marshals must make every effort possible to preserve an individual's right to a fair trial and to prevent any information that would compromise that from being included in said releases. Would that satisfy you?
That'd give me like 90% there, yeah. That's half my. That's the majority of my issues.
So then what's the 10%? Because we agree. As we
Okay,
said
I mean,
20 minutes ago.
I mean, just generally that it says statewide threats, which is again another undefined term. I still think
we
it should
didn't put
say
that
enemy
in
of the
there.
state.
Your side put it in there.
I'm aware, but I mean, it's not my side. I just stepped forward as somebody to talk. This is Fred's thing, right?
No,
Yeah.
he
I just
thinks
stepped
Fred, how
forward
do
to
you
say
feel
threats,
about
no?
that? Fred, how do you feel about that suggestion Vale just said?
What is it exactly like in simple words?
A line at the end that says, Vale, you go ahead, you said it, Bill.
Well, Crib notes that we are limited to not. We are implied or compelled. I mean, verbiage is verbiage. I'm not any kind of legal head, but that the marshals would be compelled to not compromise an individual's right to a fair trial. Because I can't see in really realistically any situation that this information would be released, and we would do that because that would just be shooting ourselves in the face and body.
Mm-hmm.
But
why does that
add
need
that
to
to
be...
the end?
Oh,
well, because
sorry.
that appears to be the primary concern. If we're getting to the stone at the center of this fruit, is that if we are compelled by this statute, by this legislation, to not compromise an individual's right to a fair trial, or to not compromise unnecessary releases of someone's information, as much as that would be the case anyway, because it makes no fucking sense to do it, would that satisfy you?
I don't think it does satisfy me, and here's the reason why. All right, we're at a point to where it could be argued that they have the authority to release the information, you know, with before the statewide threat bullshit that we got into. All right, Grayson brought up a much better point that the enemy of the state's already defined. With enemy of the state already defined, that kind of makes it a lot easier to just kind of add on to that. Why not just reports on enemies of the state and then leave everything else alone?
Because there are straight state threats that the public should be aware of,
All right,
which is why we're here.
I don't understand. I mean, this is the issue,
know,
right?
I know.
Enemy of the state is already defined as what it is. It's what you walked in here talking about.
No, we weren't. You limited the scope to that. About 15 minutes.
I yield my time, Justice. I feel like I can't contribute any more to this.
Awesome.
Okay, thank you, Bill.
Yeah.
Bailey.
No, that was your argument.
I'm going to say some stuff that
No, that was your argument.
Personally, I'm a big fan of this legislation going through. I think right now the marshals are somewhat of a boogeyman around. And in that sense, I think some more transparency from them of what they're working on and things as such would be very beneficial to everybody in San Andreas.
Yeah.
Moreover, in this whole thing, if they do something dumb, I would just impeach them or ACR them myself personally. I don't think they'd put themselves at risk. I think, if anything, this is a good thing. So people are more informed of what's going on around San Andreas. So, you know, I know that when they're saying shelter in place, it's not some guy who's just kicking dogs. It's an actual threat.
Thank you.
Okay. And
guy who shit on the floor.
Yep.
Hey there, the name's Billy Bixby. Billy's got some concerns about what a state threat might be, Mr. Marshall. Could a serial killer be a state threat?
That's a great question, Billy. So I know you may have arrived a little late. We didn't actually put that statement in there. I actually think that adds a level of confusion. But with that being said, it could. However, the public need not know who the individual is, barring there being a warrant.
Oh no!
Oh Jesus!
He's doing it again.
Oh! I'll give you a second there. I'll give you a second.
He's pooping.
He's pooping.
Oh no!
Can you like arrest him or something?
Billy's been in the line a long time.
Can't arrest people for having IBS.
Another 20,000.
Okay.
His clothes are
on. Commenting on 20 grand if you
need a charge for that.
No.
So to answer your question there, if there were a hypothetical serial killer, which I'm sure there are some out there, whom that serial killer is, absent a warrant, which would be public, the information related to the threat the individual is posing being public, yeah, sure, right? If there is, someone's got like 3 bodies on their hand, the public should be made aware that there is a serial killer. perhaps some information that can be released to the news, as happens in every state across the United States. However, the identity would not be something that would be released for obvious reasons, right? Because
Billy thinks it's real important that serial killer information gets out there so everybody can know what's happening.
Absolutely.
And so they can make sure that they hide from the serial killer and maybe make it more challenging for the serial killer.
terrorists, serial killers, all kinds of threats along those lines. Absolutely. And to the point that was made a while ago is, can't we already do this? Absolutely. Right. This formalizes it. And as was actually noted in the original set of posting. So
Billy thinks that's good then. Billy thinks serial killer information needs to get out there. Billy, that's all Billy had.
I think, look, we want to make sure the files
What a lovely fellow.
can be
Get the
released.
fuck away from me.
It's really that simple.
He's got shit in between his toes, Carmine.
Ew.
Okay, Springfield, did you lighten up the speaker or you're just there?
Yeah, I just had like a general inquiry question on the proposed legislation.
Yeah, go ahead.
I guess in both manners, if the marshals were to release information that I guess a private citizen didn't agree fit the mandate of this legislation, what does a remedy process look like?
Is that a question to me?
Yeah.
Or is that a question?
Well, to both sides, really. Like, honestly, because I'm trying to think of, like, if a citizen doesn't agree that information that's released fits within the mandate of either proposed legislation, how is remedy determined? Then what does remedy look like?
You know what? I think that's an actual pretty decent question. I think that there are a lot of things in place if you think something fucked up is gone. All right, but if you allow something like this currently into legislation where you have a governing agency, a body that you're a part of, say that they can dictate what information the public needs to be aware of, you start entering muddy waters. All right, it's just that simple. It shouldn't be like Carmine brought up a really good point of what could actually make this whole process work.
Deflect.
They have to go to the DOJ first. There has to be some type of paper trail of the information that they're making public. If we already just say, what's to stop them from low-key releasing information to the public and then fucking off and, acting like it wasn't them? There's a lot of hypotheticals of things that could actually happen that are bad, not just dog kickers and shit like that. All we need to do is, we just need to make sure that there's a check and a balance. Whatever information they're making the public aware of, or whatever party wink they're making the public aware of, there should be a paper trail of it. There should be something that at least the Department of
Justice, what this
is. Chief Justice maybe is aware of.
If I may retort, that is what this is. The release of information would have our seal, as we are the ones releasing it. Those documents are the trail. The check and balance is the DOJ. And if a filer were to bring to the DOJ a suit, be it civil, be it an ACR, be an impeachment, that right there is the check and balance. So,
well, I guess that brings into question then it's a difference between the two sides on how remedy would be observed. On the side of the petitioner, it would be that the DOJ signs off on it before release. Therefore, there should be no contest or potential remedy for disagreement from the general public on its necessity for release. On the submission side, then the potential for remedy comes from the DOJ after release in the form of civil or criminal suit, or even like impeachment process. Is that the difference that we're seeing here? Petitioner?
Okay, was that to me? I wasn't sure who you were talking to.
Well, to both. Well, mostly to both, because I'm trying to clarify. Like, I'm asking a question on both sides, really, because the question I have is about remedy and process for that. But if
I mean,
you're saying,
100
if the
not
petitioner is saying that
100%.
it has to sign off
Not-
beforehand, then there shouldn't be any contest because there's two independent sign-offs. You have a third-party release and a primary release. And therefore, if it's released with a primary and a third-party sign-off, then there shouldn't be any potential contest. So no remedies could be sought. But on the other hand, if there is no third-party release and there's a contest from a private entity saying that they don't agree that the release of information was valid or fitting within the statute, then there should be remedy options. But then how would those remedy options look?
So like Brian said earlier, there's nothing that's really stopping him from doing this right now. Right? But the thing is, if we're going to fucking put this into legislation, we have to try our best to stop this shit from being potentially bad. As written, that is very terrifying to me. All right, even with the undefined statewide threat argument that we put in there earlier that we changed and may change the enemy of the state. I'm going to be honest. It doesn't really seem like we're able to really meet in the middle. Right?
We can meet in the middle.
Here's the thing. Right? It goes from talking about enemies of the state to talking about, what about local PDs? What about local PDs reporting the stuff in their sectors? What about...
Those are good points. I think local PD
they
should work on writing legislation to release things that is within their scope. Of course they should.
Can I be honest?
Yeah.
I think the one thing that this Department of Justice needs to pull away from is the millions and millions and pieces of legislation that we have at this point. All right. What we need to do is here's the thing that I don't have a problem with. Don't codify this in legislation. Let them already operate how the fuck they want. If people got a problem with it, they can ACR them. They can impeach them. They can seek, criminal charges.
That's what I said.
Then why don't you pull the whole thing? Pull the whole thing and just leave the legislation as it is without adding this shit to it. Do whatever the fuck you want.
I actually have a concern regarding that same matter and a comment on that. Actually, I'm in agreement of the legislation only because it closes a potential loophole.
Are you on my side?
Removing culpability.
What?
Huh?
Let's bring you talk.
No, not you. Sorry, I'm still thinking what Brad just said.
I do think there should be a checks and balances in place. Here's the thing: we're going to be arguing all day.
Well,
all right, we're not getting anywhere.
Let Springfield finish what you're saying.
Yeah.
All right.
Yeah.
Thank you. I was mostly bringing up my support in this legislation as its original submission because it does close a loophole in culpability.
Mm-hmm.
Who's to say that the marshals can't just go, hey, I want to release this information, FOIA this from me. And that releases the culpability from the marshals on the release of that data because they're just following the legislation of FOIA.
But they can block the FOIA process.
No.
By saying it's an ongoing investigation. It literally said that in the legislation that they can share information.
Yeah, but they can
outside
do that anyway.
and then
it's
already a thing.
Yeah, the clarity that was added there.
The state marshals.
No. So the clarity that was added there, just for clarity for the room, that was not something we added. That was actually added by another party, but it makes sense because what that is saying.
It was added by the state, actually.
Oh, there you go.
They asked me to put that in.
Yeah.
Which part did they ask you to put in?
The very end about the FOIA process.
Yeah, so
You're
that whole
looking at
last
the
sentence,
edited one.
Yeah. And
information.
Go ahead.
I'm on the change right now. Yeah, we are on the PRT training.
What that is saying there is that if something were released, that doesn't inherently mean that the related documentation can be immediately obtained and that the normal FOIA process still needs to be used. But consider the following.
It's exempt.
It says more than that.
It says information released at the San Andreas State Marshal's discretion in this manner is still exempt from FOIA. It's exempt from FOIA.
Provided that the investigation is still ongoing. So what that means, I'll
means
explain.
They have to prove it to the DOJ.
Exactly. Yeah. And the thing you want to consider is that the public doesn't even know something is occurring. So they, without the release of information, don't even know that there is information that they can seek. That's what the big thing about transparency is, right?
I want to put my concern into a hypothetical scenario. I am a marshal who wants to maliciously release information from an investigation that could personally damage somebody's reputation. But I don't want to be held culpable for the damages. Hey friend, I have this information, FOIA it from me. Hey, I'm requesting a FOIA of the information regarding this information. Well, it's not an ongoing investigation anymore, so here you go, friend. Release it to the public. Now I've just followed the FOIA legislation, so I can't be held personally culpable for following legislation. But by adding and defining it that it should follow a certain practice that's decided by the marshals actually can be held more culpable for personal damages for maliciously releasing information.
That's not true. That is actually very false. It is all you have to do is say that it's an ongoing investigation, and you can still release information from the ongoing investigation. What do you mean statute? An ongoing investigation? I mean, it's not like the public's going to be aware to the day that you inquired about some incident to the very end of statute of limitations.
But without this, they don't even know the thing is happening. If there was a entity in government, in the criminal underworld, and they are doing things that are unbecoming, illegal, illicit, any number of things, the public would not even know to seek those records until some semblance of those records are released. After which, the citizenry can utilize that information that they did not have access to before, and then garner the information that they need via the FOIA. Right?
What do you mean they can't get the information if it's still under investigation, but you can leak it? You can share the information still. It states this right here, that you can share information you deem necessary with the public, even exempt from FOIA.
No.
It's under investigation.
If it's under investigation, you can't do it anyways, right?
What do you mean? It
example
says you can.
No. You're scoping your argument to just under investigative information.
It says that.
So as an example,
that the information's exempt from FOIA,
provided
that the San Andreas State Marshals have an ongoing investigation,
as decided,
you get to spin
as decided by the FOIA process. And mind you, we didn't write this, right? So I think a lot of people understand exactly what that sentence means. You may not understand it, right? All that's trying to say.
Let's not insult me. It's literally. What do you mean? So tell me then. What is it trying to say then?
What it is saying is
having oversight
and the FOIA process.
Correct.
What about the FOIA process?
You use the FOIA process.
All you have to prove is that it's an ongoing investigation. Why are you guys acting like this ain't an easy loophole to fucking exploit? Why are you acting like
Fred? Prove to who?
Prove to the DOJ. Exactly.
What
are they going to do? Thumb through 30 fucking documents to see if it's an ongoing investigation? We know exactly what's going to happen. They're going to.
We might have to, yeah.
Yeah. That's
you might.
Job.
That does happen.
Yeah.
If I have to.
Yes.
But how do you know?
That currently happens.
But who has? So are you guys going to give them access to everything?
Okay, because it really happens when people challenge FOIA denials. Here's how the process goes. If someone denies a FOIA because it's an active investigation, and someone then challenges that, if I or any other judge were to pick that up, we would then go to the PD that denied it, who said it's an active investigation, and we'd say, show us your proof. Show us that it's an active investigation. And if they
There's
show
one
us
right
a
now
report that was last edited 5 days ago, tough shit, you're releasing what you denied because that's not active.
Yeah. And on that point too, as far as SASM is concerned, and we've had these conversations with the DOJ, some number of them, I also agree that if there was a better means by which things got auto-released to the public, I'm all board for that shit too, right? Like if I had to pull open my MDT every day and it showed every little document that is currently under, investigation with a tag with a timer on it.
The privacy.
What?
people have the right to privacy. Maybe you want to share their information, but maybe they don't.
I
want
never
that
said their information. What?
You said
I
information
don't
about
think we currently
ongoing
have that option,
investigation.
though.
Yeah.
If we get FOIA'd for the
Yeah,
information, we don't have an
I'm
option.
very
We have to release
pro
it.
release of information. I am also equally pro redacting individual citizenry's names and such from documents so that the public can know what the hell's going on. Right now, the public doesn't
But there's
know.
nothing stopping you from doing that now.
Civil damages.
Yeah, well, this legislation, as mentioned 15 minutes ago, now 20 minutes ago, I've lost track of time. This was put here because there are people that for some reason do not understand the simple concept of law enforcement releasing information to the public. This not only clarifies it, but it removes those arguments so you're not getting dragged to court with something that has a very obvious conclusion, right?
Then why not just narrow the scope down to enemies of the state?
So
Redefine enemies of
you're
the state
moving
the way
the
you want, and then be
goalposts
done
now.
with this whole thing.
You know,
I'm not moving the goalposts. It was the same thing I said about statewide threats. Now it's
Because-
just enemy of state because that's already exists.
because
Legislation.
are you aware
How's that
of what
moving
are you aware what the enemy of the state is?
Yeah, I read it a couple times while we're in
Okay,
here.
understood. So, are you aware that the enemy of the state is very specific to very particular high-level violent government anti-state actors? And that would not cover like 90% of cases for information that does have state-level effects that should be, for matters that should be released to the public? And it would simply be adding more red tape from that would prevent the citizenry to get the transparency that they deserve.
Yeah,
right?
because you're muddying the waters of what it is. So here's the thing, right? Let the local police departments defer and decide what information gets, unloaded in their sectors. Let the local police
Sure.
departments work
They
together.
already
on that
can.
stuff. You focus on the statewide threats.
That's what we're doing
you
here.
Focus on the enemies of the state. Let the other policing agencies take care of the other stuff and let them be culpable.
Enemy of the
see, here's the thing.
state.
So, one
Enemy
second,
of the
one second, Brian.
state.
I'm speaking. I'm speaking, Brian. I'm speaking. So here's the thing that I don't understand. You wish to assert yourself up to this higher standard, right? You wish to assert yourself to this place where
No.
you are the one who governs, where you are the
No.
one who decides. Then why not just have it be your scope? Why should you be speaking on stuff that's happening in Los Santos and Blaine County?
I'll
right?
answer that.
That outside of an enemy of the state.
I
Let
think
it
this
be the
is
enemy of state shit.
this is where your
Let them have the other shit.
This is where your confusion's coming from. Enemy of the state is a very specific category that at present only is related to some basis related matters. It does not extend beyond that. It does not cover the full scope of state matters.
I think Springfield wants to say something.
Yeah, I think we can probably go back and forth on a loop on this forever, but I just wanted to address the original inquiry I had on that. If that's my biggest concern is about limiting the subject scope and how remedies can be had in violation of that scope. So say the state marshals release information that's not particularly damaging to one individual private party. Maybe it's properly redacted, but that an individual member of our society doesn't agree that the
like a
information
sandwich or
fits
something,
within
man.
that limited scope. What does the remedy process look like as far as that citizen raising the concern saying, hey, I don't think this is in scope?
That's
How
on
do
the
they bring
local
it
police
forward?
departments. Yeah, I mean, it's
The
simple
local
as
police
that.
department decides, well, what's the remedy
No, it's
for
on
that,
the
for that
it's
citizen?
on the local
Sandwich,
police
man.
departments to bring that stuff to action.
Why are you doing
Like to bring that stuff in. Like, here's the thing, right? And this is one of the main reasons why I had such a hard time about.
I don't think he
question being
understands
asked is,
Well, I am.
what can someone do who has an issue with it? What can they do to seek
thank you.
the fix?
Well, we already had that discussion several times over at this point. I don't know why we keep going.
I don't think he
Brian
knows
Knight
what
said
enemy.
ACR me, bro, impeach me, bro, a million times. Like,
Mm-hmm.
why, we've already talked about this a million times. How about we focus on talking about like the overarching issues with everything instead of what the remedy is? The remedies exist. The remedies do exist. Justice.
Because I'm
Justice
a citizen
Falconer.
and I have a concern I'm bringing forward about the legislation, and that's a primary legislation. If we can make law all day, but if there's no remedy for violation of that law, then there's no point in the law.
Yeah, but you know what that is. You know, you're here as a citizen,
I
but you're
don't.
also you got your marshal
That's why I'm
badge around
asking.
your neck.
I'm okay. If we're just going
So
to
are you a
demean my
citizen?
words,
Okay.
Well, I mean,
yes,
are you a
I'm a
citizen
citizen
now,
of
or are
this
you a
state.
government employee? What capacity are you in right now?
From what I can gather, both sides agree that ACRs or impeachments or civil suits would be the remedy. Does either side disagree with that?
No one disagrees with
No,
that.
absolutely.
Okay. Does that satisfy
Well, it's
your
criminal
question,
suits.
Springfield?
I kind of just want to know, like, what was the clause under impeachment and ACR? Because I mean, if we agree that that's the remedy, under what clause of impeachment? Because I'm just trying to make sure I know.
It would also include like civil, right? As well. So,
But then how? If it's not, somebody has to be damaged by it.
it depends on the
subject matter that's released. If there's subject matter released about like the plague, and they're like, well, that's not fitting the definition of a statewide threat at its point because it's only, technically it's violating Sandy Shores right now. It's not a statewide threat. And I go, that's a violation of the legislation put forward. What's my remedy? If it's not technically an ACRable offense, there's no civil remedy because I didn't seek damages. What's the remedy that can be seen for it? If there's no potential remedy, then what's the point of the legislation?
Violation of oath, incompetence. There's so many it could fall under.
Yeah. I think, and what you're saying right there is actually an argument for why these scoping matters are kind of odd to begin with, right?
No, it's not. It's not odd at all because it doesn't take a rocket scientist to declare. That's what SAM is for. We keep on, listen, Your Honor, people of the court,
Your Honor.
I'm tired of the constant hypotheticals. Listen, the SAMA director is right here. All right, the SAMA director would be aware of this, and she would therefore go through the route to be like, hey, the SAMA director steps in. This is a threat not just to Blaine County. This is a threat to the whole fucking island. People need to know. You see, that's different. And why do we keep getting locked on to this whole thing about like these diseases and these hypotheticals? This isn't personal information being leaked. This. There's no victim. This is a victimless crime right here. All right, no one's. Is the Black Plague going to fucking ACR Brian Knight? No. We keep on hyper fixating and focusing on these hypothetical situations that can easily be explained. SAMA director right there. She is the director of the San Andreas Medical Association.
Yeah, she is.
I agree. We keep getting fixated and we are going in circles.
Yeah,
exactly.
Is there my ask is there a remedy that can be provided in writing as to what the alternative writing of this would be to satisfy
I'll say it, but I ain't writing.
To satisfy the concerns. There's a whole lot that's been said here. I in my opinion, I think Pred has agreed with us in some points and then disagreed 5 minutes later and then re-agreed. It's kind of gone back and forth, to be honest. I think as far as SASM is concerned, we do believe, even before we wrote this, and was told to us by multiple individuals, that we are able to release files to the public. There are matters that we can release to the public. Having it in written form is good as it draws clarity to the people of San Andreas in written form. If there are concerns about individual rights being trifled as a part of the releasing of documents, we agree. Internally, we would redact, given the fact that we are well aware of civil ACR impeachment and other forms of liabilities and resolution. But we are also not opposed to that being written into legislation. The next point that I would like to draw here is there has been a lot of back and forth as to what our meaning is. Our meaning is statewide threats or any threats to the state in general. We do not scope it to simply enemies of the state, as we are aware, as is the public, that the threats go beyond the scope of just the enemies of the state, which I am going to suggest that I think there is a gross misunderstanding of what that is. And we can provide many examples. And I will finalize by saying that the only reason for using any hypotheticals is because 95% of the argument that was presented here against this is purely hypotheticals. All right.
Not
Thank you.
hypothetical.
Okay. Okay. Right. Here's what we're gonna do. Fred, you said you have a proposed amendment, you're not gonna write it down. So here's what we're gonna do. You're gonna say what your proposed amendment is. Rohan here is gonna write it down.
You get the one-handed guy to do it.
Brian will then read it. If Brian agrees, happy days. We post the amendment, it goes to contest again.
Okay.
Brian doesn't agree, goes to a vote. Okay?
All right.
All right, so what we're doing here, right, is we're kind of opening Pandora's box of information if we allow this thing to go through. So what I'm going to do actually is I am not willing to make any amendments. I am against this entire piece of legislation going through, and I wish for it to go to vote. That is what I wish for.
All right. It will go to a public vote.
Okay.
Perfect.
All right. Easy.
Well, there's 2 hours I can't get back.
Oh. All right. Well.
Hey, Brian, before you leave,
Yep.
I have a FOIA request for you.
Sure. Just let my department know about it.
Really?
I don't get it. I don't get what the concern is. I don't get it. I don't get it.
It hurt my brain really bad.
We all agree. I don't get it.
I think the public needs to know these things. It's things that we can do anyways. I think it's good for the public to know what that looks like. What I would have liked to have seen come out of this is more discussion about restrictions and fears that people have. But I think
That's kind of what I was trying to get to the bottom of because I didn't quite understand what the impasse was.
Yeah.
Right. It seems objectively a good thing from both the preservation of personal liberty and not fucking people over and poisoning the well, etc., and also from a prosecution standpoint to not overshare and fuck the dog before it ends up in a courtroom.
How you doing? I didn't even recognize.
I don't see why that is
That's so
a point of contention.
Do I have kicky face?
Yeah.
I don't get it.
Well, I don't understand why he was so hard pushed on state enemies of the state. I mean, do people not have the right to know more than just
it's a bad faith argument, right? It's why I initially caught him when he was like, "So we're just talking about faceless," and I said, "No, we're not." Right? And I think he's failing to understand.
If an undefined someone is planting fucking anthrax bombs, right?
Yes.
Then Sama will say, "Here's what
Please
anthrax
don't
does."
mention anthrax, please.
Well, just any kind of biological weapon, right? Like
Yeah.
biological weapon X. Sure.
I mean, I
Someone's
did it with the
planting-
plague. I announced it to the public when I was Sama
using
director.
drones to drop bombs.
But then, so like your part would be, this is the plague.
Be
This is
aware
the
of
medical
drones.
parts about the plague, and our part would be
It-
like,
You
wouldn't
stay
release
the
the part
fuck
of the
away from
investigation
pestilence, you dumb motherfuckers.
It would be stay away from
XYZ.
fucking
XYZ.
stay away from him. But also, it was with the plague. I announced it to the public, gave basically a TLDR of what the symptoms are, and to come to CMC for if you have any like further complications and shit.
Right.
Mm.
Yeah, we're on the same page. Well,
Forget about the people.
Oh, wait.
They don't
Brian,
deserve safety.
Yep.
do you wanna
They
talk to
don't-
me
They
still?
don't need it.
Yes.
Cold blood.
Give
Cool
me
down.
and Blunt just a little bit, and we'll
Okay.
come right to you.
All right, I'm probably not gonna go on duty, but I'll say.
Yep. Absolutely.
All right, we'll give you a call when.
Yeah, give me a call and I'll say.
Thank you, Doc.
Alfred didn't want us to. I don't get it. I don't
Yeah.
get it. I don't get it.
I
don't
will
get
tell
it.
you the last 5 or 6 weeks have been miserable when it comes to docket related things. Simple charges have turned into pretrial after this hearing, after that hearing, to the point that one of our cases took 30 days to complete where the video expired, right?
Oh my god.
Yeah. So I don't think there was an intention other than doom spiral over hypotheticals and straw men. I mean, at the end of the day, I mean, Blunt was telling me this, other members of the judiciary were telling me this, that we can release files anyways. But I think the reason we put it forward is I personally, Brian Knight, want to see things like this codified in law so there is no confusion, right? The public shouldn't be confused what we're doing, because a lot of our authority is very, very wide, right? But
No, Brian, transparency bad.
yeah, yo, that shit was crazy.
Not have a PIO. All right.
This is